Yes, good evening to everybody. Welcome to the class of the family law that I am dealing the Muslim law. And yesterday that I dealt, what I dealt yesterday class? Salient features of the yes, what I did in the yesterday class. Are you hearing me?
Special Marriage Act, sir. Special Marriage
Taking
Act.
so much time then. Why are you taking so much time to give the answer to my question?
Sir, I did not unmute, sir.
Okay,
After,
you have to
sorry.
unmute it and mute it when you want to say, because it's not the first time that you are doing. Okay, no matter, it is. And today we would like to deal the matrimonial remedies in the Divorce Act. Of course, if you take any matrimonial remedy, it will be the common in all the space. Yes, what did you understand by matrimonial remedy? Any idea? Unmute and give me the answer.
Matrimonial divorce, restitution of conjugal rights, judicial separation. These are remedies of
Nullity of the marriage.
nullity of the marriage. Divorce.
Alimony.
Alimony.
So these are all the, and the child custody, maintenance. So these are all consequences will come when there would be a divorce. So that we will concentrate on today class. And let us see again the Divorce Act in the different angle we will see now. So Divorce Act, there is the Indian Divorce Act. Already I told you the Indian is removed in the Indian Divorce Amendment Act 2001, Section 2, where the India is omitted. Now we can say the Divorce Act 1869. Divorce or divorce? The way that you want to pronounce
Divorce, sir.
divorce.
Divorce.
Divorce. So that is the way, divorce. So divorce is the legal dissolution of the marital union between a man and a woman. They say man and a woman. They did not say man and a man. Because now the gay marriages are allowed, man and a man, lesbian marriages are allowed, then woman and a woman. So in some countries, not all the countries, not in India. According to this act, the separation is granted by the
Also
court.
starting, sir. Now
Yes.
India's also they are marrying, sir. Man and woman and woman. They are marrying, sir. The train started.
No, I don't think that in India they recognize that marriage is a valid marriage.
Okay.
In India, I did not see that marriage is a man and a woman and a woman, they married, they recognize it here. But one thing is very much clear, okay, these gays are there, okay, let them have their own union, and gay is different, transgender is different again. So this is the different aspect of it. Because in India, women are many are there. That's why if such a thing would be there, one man should marry 2 or 3 women now. The Hindu Marriage Act should be changed if such a situation comes. We don't know whether situation comes or not. There's a different issue because it's against the nature. That's my point. It is against the nature. If a person does anything against the nature, in one day, in another day, there would be a disaster on the human mankind. So that was actually the story. Okay, according to this act, the separation is granted by the court of law after receiving a petition from either the wife or a husband. So when the marriage became a difficult task to continue it, then the only remedy is the divorce. And divorce is followed with the granting the alimony. So if the divorce is given, do you think that they will keep God? No. Then you are granting the alimony, that is the maintenance of the divorced wife as well as the children, and the child custody, whatever the child custody, if they are the children, and the child visitation. What is the child visitation?
Sir,
What is the child visitation?
if both the wife and husband are divorced, then if one if the child will if court grants the custody to either of the man or woman, then the other have certain rights child visitation rights. This is called.
Child visitation means any one of the parents should have to visit the child in the weekly, this hours. It is granted by the court, that is called child visitation. Means child visiting hours in other way. The distribution of the property, then how the property would be disputed, and the distribution of the debts. So these are all the consequences would come when the divorce are there. And before opting for the divorce, the Christian couple would aware of the fact that the divorce procedure in our country, whatever the country's procedure would be there in the divorce according to the act is concerned, then so in this venture, in this article, this paper will take it, what is the Divorce Act detail. So the Divorce Act, an outline is, and the Divorce Act was drafted into the Indian legal system in the year, of course, 1869. In India, divorce rule and procedure varies according to the community of the couple. So, as stated about divorce among the Christian is governed by the Indian couples, governed by the Indian Divorce Act 1869. That if the matter comes to the Hindus, Buddhists, Sikhs, Jains, the Hindu Marriage Act 1955 will take care of it. When the matter comes to the Muslims, the Dissolution of Muslim Marriage Act 1939 will take into the consideration. Then the Parsis and the Parsi marriage, then and Divorce Act, there is a separate act would be there. Parsi Marriage and Divorce Act 1936 will be applicable to the Parsis. And the civil and the inter-community marriages by the Special Marriage Act of 1956. So intercaste marriages without any reference to the caste, creed, religion, and then the people go for the Special Marriage Act. So that will be applicable over there, and the children will come under the Indian Succession Act if the succession comes such a child. The state, of course, I told you the 370 is scrapped out, then there is no special weightage is given over there. But as far as the study is concerned, we should study the state of Jammu and Kashmir, which is excluded under this ambit of the Divorce Act at the time, because it is having a different entity, because it is a princely state, but later it is, I don't say amalgamated, but I can say, but it will be come under the Union of India, but with the special provisions. That's why we will say except Jammu and Kashmir in most of the acts we will say, because the act is different, even the penal code also at the time. The Randir penal code was there, which will be promulgated, which will be used in the Jammu and Kashmir in the instead of the IPC. Okay.
Yes.
Did you know it? There is a Randir penal code was used in the Jammu and Kashmir for the penal actions there. But here in the IPC, Indian Penal Code would be used for the criminal actions in that entire territory of India. The types of the divorce petitions, I told you, Christian couples can get into divorce by the mutual consent, means no fault divorce, or mutual divorce, or we can say either spouse may file for the divorce without a consent of the other. There is a fault divorce. If any one of the spouse made a fault over there, then the other spouse will having the right to get the divorce as per the Indian Divorce Act. That is a yes. Then let us see the divorce with a mutual consent, because both the parties should be present over there, and which is inserted in later part. That is where we can say Section 10, capital A of the Divorce Act 1869. A new provision was incorporated over there. At that separation, at least for the 2 years would be there. They have to separate, live together. No BBC at the time. The couple only needs to provide the have not been living in a husband and wife during that period. They have to show it. Then another condition should be fulfilled over there is the couple should be separated for over a year. At least over a year they should be separated over there. Number one. Number two, the couple should be able to prove that they have not been able to live together because they are not residing the same roof. Then there is no BBC also. Matters of the children custody, maintenance, and property need to be agreed to mutually. Then they have to take the care of the children are there who can take the care of the children, and whatever the custody is concerned, whatever the maintenance is concerned, regarding the inheritance is concerned, that also be decided before they are going to take the mutual
Divorce.
mutual
Mutual consent.
divorce. Yes. Now let us see what is alimony, that our maintenance issues are concerned. It is one of the matrimonial remedy. Yes. These are the three aspects regarding which the couple have to reach a consensus. One is the alimony or maintenance issue. As per the divorce law, there is no minimum and maximum limit of support. The almost of the maintenance depends upon the status of the another spouse, the capacity, dependence, and the qualification regarding and the age. These are all the count taken into consideration when you are fixing the amount to as an alimony to the another spouse. If that spouse solely depend upon this divorced husband. Yes, custody of the child. Let us see. The second consideration would be the custody of the child. Child custody in the mutual consent divorce also be shared or joint exclusive depending upon the understanding of the spouses. It will be their child custody. But in general, as per the Muslim law, what we studied over there, if the girl is at the 7 years and the boy is 2 years, am I right?
Yes,
Am I right?
yes, sir.
Very good, very good. Then let us see the and another point is also the CRC is there. What is CRC?
Criminal
United
Procedure Code.
Nations CRC. Yes.
Yes, criminal.
Convention of Rights, Child Rights. Child
Yes.
Rights Convention. It is the international instrument would be there that only decide completion of the 18 years only the majority. So the same definition will use it in the Indian Majority Act because we ratified and we are the signatory for the convention and we domesticated the provisions in our municipal law, means in our state laws or central laws. So that was the custody and the best interest of the child. That is the wording they used in the CRC. The best interest of the child, whether the child with the custody of the mother, whether the child with the custody of the father, even though child age is less than 7 years, if the girl is concerned, at that instance, the code will consider it which one is the best way to make the best interest of the child and where he should be, where the child should be kept under whose custody. And sometimes they can deviate also the principle which is promulgated over there and which is generally followed. Am I right?
Yes, sir.
Okay, next is property rights. The third is the property right. These couples, the couples must decide who gets which part of the property, both mobile and immobile property. Regarding the bank accounts and everything must be divided. So it will be clearly mentioned what the property goes to the children, what the property goes to the divorced wife. Yes, next, the duration of the divorce. The duration of the divorce by mutual consent varies from 6 to 18 months, depending on the decision of the court. Generally, the breathing period would be given because at that instance, it will be a possibility that they may reconcile it. So that was there. The loose time would be given more for the reconciliation of the both the spouses. Then dissolution of marriage, divorce without a mutual consent. Of course, depending upon the factor which you have made, some 7 to 8 or 9 factors are there where a woman can get the divorce under the Dissolution of Muslim Marriage Act of 1939. So, according to the Indian Divorce Act, here either the husband or wife can file the petition for the dissolution of marriage, and we studied in yesterday class or before yesterday class when I was dealing the the Divorce Act is the condition when they can file the petition are explained in detail below. So, petition by the husband. Any husband can present a petition to the district court or the high court praying that his marriage needs to be dissolved. What is the ground? On the ground that his wife has been guilty of adultery since the solemnization of the marriage. Since the solemnization of the marriage, she is indulging in the extramarital affairs with somebody else. So there will be a quite good ground to take the divorce. According to this act, much marriage might be solemnized according to the Christian Marriage Act. So generally, what are the marriages is solemnized under the Christian Marriage Act, and those acts can be only could get it the divorce by following certain norms or based on certain grounds. Then that is where the husband is concerned. Then if the wife wants to move the
So
petition,
husband, Sir, only husband can wife only in case of adultery, sir. Cruelty of wife, all he can apply, sir. Husband can also apply cruelty of wife.
Yes. Oh, do you think that only cruelty will be done by the husband from the husband's side to the woman? The more cruelty would be there from the woman to even the husband also. Yes, because they say spouse, they say. So generally, when the spouse comes over there, anyone who could undergo such a thing, they can make it and file a case. Even a wife should not torture the husband. No, let you come out of your father and mother's house and we live separately. It is also a torture. It is also a cruelty. It is also a harassment. Is it clear?
Yes, sir.
Because a wife should leave their parents and come to the husband's parents. It is a different, again, whether the husband wants to live separately from the parents or whether the husband wants to live with the parents. Because without the parents, husband is no more in existence. So, if the wife will pressurize the husband to leave your father and mother and let we have a separate house and we'll live together, then even also that amounts to the coercion, not coercion, harassment, including the cruelty. So the petition by the wife, yes, the wife can present a petition to the district court or the high court or at least the first class judicial magistrate court for the dissolution of the marriage. The wife can file a such petition under any one of the following circumstances. We already read. And if her husband has exchanged his profess for the Christianity for the profess of some other religion, suppose if he is professing the Christianity in general before the marriage, but later on that he has renounced the Christianity and professing the Islam or professing the Hinduism, Jainism, Buddhism, or so on and so forth, other than the Christianity, then it is a good ground to take the divorce by the spouse, that is the wife. Then second point is if the husband went through a form of marriage with another woman, means second marriage. If that's also when the first marriage spouse is alive, the second marriage is a void marriage, and we can also say it's a bigamy. If her husband had been guilty of the incestuous adultery since the solemnization of the marriage, so husband is having a close marital relations with the close relatives. At that instance, also it is a ground to get the divorce by the wife. Then the next part is in the case of the bigamy with adultery. So if you go have a sex with another woman, that is a adultery. And if you go already a married man without divorcing the wife and conducting the second marriage, and that is also amounts to the bigamy. It is not adultery because they are getting married because their marriage is a void marriage. The reason is one of the spouse is still alive because they did not take completely the divorce. So next part is in the case of the marriage with another woman with adultery. See, if the man stays with another woman or woman stays with another man, in both the cases, it is a ground for the divorce. Yes. In case of rape, suppose if you may rape somebody else, yes, it's a good ground for getting the divorce. Even a sodomy, that is the anal sex or the oral sex, other than the vaginal sex, we can say sodomy, or a bestiality. This is the one of the BBC with a human being with the lower animals. The ABBC, sexual intercourse between the man and the animal, is called the bestiality. If such a thing also be there, there is a good ground to get the divorce. In case of adultery, coupled with such cruelty as without adultery, would have entitled her to divorce mensa et toro. That is another type of the divorce, mensa et toro. That means a divorce a mensa et toro is rather a separation of the parties by act of law. They are the separation not of by their conduct. It is the act of the parties by the act of law with a dissolution of the marriage. Because the act of law, operation of law will come into the picture and the marriage will be dissolved. Such a marriage, we can say, the mensa et toro. It may be granted for the cause of the extreme cruelty or desertion of the wife by the husband. So, in the cases of the extreme cruelty or desertion of the wife by the husband, in such cases, this mensa et toro could be used over there. Then the last one is in the case of the adultery coupled with the desertion. See, first number one, adultery, they did it. Number two, it is a desertion, also they made it out without a reasonable excuse for 2 years consecutively or more. I say consecutively, means it is stretch. That is mean consecutiveness. So that is also a very equal ground for the getting the divorce. So now, content of the petition, how it could be there. Every such petition should contain the distinctly as the nature of the case, permit the facts on which the claim to have such a marriage dissolved are founded. So they have to maintain it and write it. The content should be there in the petition. That what you want to expect from this petition. Then dismissal of the petition. The court will dismiss the petition for any following cases. What if there is no proper allegation would be there, then it can be dismissed also. In case of the evidence for any petition is not satisfied by the court, or the petitioner case has not been proved, so in such a case they will dismiss it also. They don't entertain such a petition. If the court is not satisfied that the alleged adultery has been committed, because the charge is made that the adultery, but it is not proved over there by the defense, that the petitioner has during the marriage been accessory to or convincing or conniving at the or the going through of the said form of marriages of the adultery of other party to the marriage, or has condoned the adultery complained of. Suppose if he has condoned the adultery complained of, okay, we can make it so, because he also indulged in such an activity earlier. So it is a compensated, it is a set off, we can say, in one way, in another way. So next point is, if the petitioner is prosecuted in collusion with either of the respondent and any of these said cases, the court will dismiss the petition. Suppose that there is a collusion between the two parties, okay, we will say like this and you say like this, and later on these two people will make say that let the insurance company will be held liable, or if it is the accident case, or if it is the marriage case, then the husband would be held liable to pay the compensation. Are you following me?
Yes, sir.
So when the district court dismisses the petition under this act, in the divorce act, the petition can present a similar petition to the high court. Suppose if you are aggrieved by the lower court, then you do have the every right to go to the appeal to the
Higher court.
higher court. Either higher court may be the high court, or higher court may be the Supreme Court. So decree for the dissolving of the marriage. Yes. So if some of the conditions are fulfilled over there, then the decree will be there to dissolve the marriage, because court has such a provisions, that the statutory provisions are there. In the case the court is satisfied that the evidence of the case of the petition has been proved, yes, it is also proved, the court will pronounce a decree declaring such a marriage to be dissolved. So, according to this act, the court will not be bound to pronounce each decree for the following cases. So, every time the court is not pronounced the decree for the cases below which is given, it is if it finds that the petitioner has been guilty of adultery. Suppose if such a question comes over there, then they will instigate. They say no, it is not. The petitioner has been guilty of the adultery. Then he will be scot free. Will be released. Then, if the petitioner has been guilty of the unreasonable delay in presenting or prosecuting such a petition, suppose if he is a very dormant, yes, for a dormant man, court will not help it. The court will help that man who comes and knocks at the door of the court. So that is the another guilt. The guilty is unreasonable time in presenting or prosecuting such a petition. The third point is, in case of cruelty towards other party to the marriage, either to the other party or to the marriage is concerned, a cruelty will be shown. Yes, that also a good ground to get the divorce. Yes. In case of having deserted or willfully separated himself or herself from another party before the adultery complaint or without any reasonable excuse. So, if any reasonable excuse are not there at the time, if they are living separately, means the desertion would be there. That is a good ground to get the divorce by any one of the party. Then, in case of such a willfully neglect or misconduct towards the other party has conducted to the adultery, even such a thing also it's amount to be the adultery in addition to the other provisions of the criminal act. So confirmation of decree for the resolution. So now every decree of the resolution of the marriage by the district judge will be subject to the confirmation by the court. So they will try to take the confirmation from the high court also whether they have committed any mistake or not. So for cross-checking, sir, for cross-checking they can go for the lower court. No, sir, no. Lower court doesn't have that much power to think whether it is true or not. That's why verification by the high court, it will go over there. So the High Court will verify the cases of the confirmation of your decree for the resolution of the marriage. If the court composed of the 3 judges, the opinion of the majority will prevail. In case of the court composed of the 2 judges, the option of the senior judge will be taken. If the High Court needs to go further equality and additional evidences which can direct an inquiry made by the evidence to be taken. So now let us see. You read this passage, paragraph. Yes.
The result of the inquiry and the additional evidence will be certified to the High Court by the district judge. And the High
Yes.
Court will make an order confirming the decree for dissolution of marriage.
So explain.
If it is appealed, sir, if the divorce is appealed, then the inquiry and the additional evidence that will be certified by the district judge to the High Court. The High Court will make an order confirming the decree for dissolution of marriage. If the divorce, if an appeal is made, then the High Court, the district judge will.
If a new evidence is found over there, additional evidence is found over there, at that instance, High Court will keep in the view and they will reverse the judgment also. Because new additional evidence has come over there. So petition for the decree of nullity. Yes, when you say the nullity, for instance, if the husband is important at the time the marriage is nullity. So any husband or wife can present a petition to the district court or the high court, praying that his or her marriage may be declared as null and void. Decree of nullity will made on any one of the following. The grounds are there where you can say the nullity of the marriage. Number 1, the respondent was essential at the time of the marriage and at the time of the institution of the suit. So the respondent was essential at the time because without him the marriage will not be conducted. Is it or not?
Yes, sir.
So number 2, the couples are within the prohibited degree of the consanguinity or affinity. So they say prohibited either the consanguinity or by the affinity. By the both the means, if the couples are exposed to it without having the mask, then naturally, of course, mask is compulsory here. Yes.
Sir?
Mask is compulsory here. Yes, because the pandemic mask is compulsory even for conducting the marriage also. What do you say?
Yes, sir.
Number 1 is the prohibited degree should have to be taken into consideration. And number 3, in case of either party as a lunatic, idiot, or insane, at the time of the marriage, yes, such a marriage will be nullity from the beginning only. In the case of the former husband or wife, either party was living at the time of the solemnization. If any one of the spouses is living at the time of the solemnization of the second marriage, even it is also nullity. And the marriage was such former husband or wife was then in force. So nullity comes in all these grounds 1, 2, 3, 4. So nothing in this section will affect the jurisdiction of the High Court or to make the decree of the nullity of marriage on the ground that the consent of either party was obtained with the force or fraud. Yes, if the both of the consent is obtained with the force and fraud, then we can go for that. It is a nullity of the marriage. because the consent they have taken only by the force and by fraud. So confirmation of a degree of nullity. How? Every degree of nullity made by the district judge will be subject to confirmation by the High Court. So whatever the decision is taken by the lower court, that is the district court, it should be confirmed by the High Court, respective High Courts. So jurisdictional separation. Jurisdictional separation is a legal profession, legal separation between the husband and the wife, granted by the court on a petition either from either the husband or the wife or from the both. Both they can make also. In judicial separation, the marital tie between the wife and husband continue to exist, no doubt, and neither of them enjoys the freedom to be remarried. No, they cannot enjoy the freedom to remarry it, because once they do so, they will lose the alimony. So the husband or wife can obtain the decree of the judicial separation. Yes, they can make it a judicial separation at the time that each and everybody could know what is the value of the wife and what is the value of the husband. On the ground of the adultery or cruelty of the decision without a reasonable excuse for the 2 years or more, and such a decree would have the effect of the divorce under the Indian Divorce Act. Of course, the husband or wife obtaining a decree of judicial separation, even judicial separation also one of the separation, of course, later on it will be converted into the divorce. In the beginning, judicial separation, and the later on it will be divorce, it becomes. So now application of the juridical separation. Regarding the petition for the juridical separation can be applied on the ground of the adultery or the cruelty or decision without the reasonable excuse for the 2 years or more. Yes, either the husband or wife can make the application to whom the judicial separation to the competent authority, not less than the rank of the first class judicial magistrate, and a ground by showing the ground they devote the petition to the district court and the high court, as the case may be. On being satisfied with the truth of a statement made in such a way, petition will grant a judicial
Sir, for how
decree
many
or
years?
separation of accordingly. So other
Sir, for
questions
how
then,
many?
yes,
Sir, for how many years judicial separation will be granted, sir?
see 2 years generally.
2 years. After
Yes.
2 years, they should unite, sir, or they should take
Yeah,
divorce.
because they will be deemed to the wife and husband, but there would not be any BBC, no body to body contact. When such a thing would be there, then only it will be confirmed as a divorce later part. But nowadays, there is a clear provision is there. If the 2 years separation would be there, or living the means is nothing but desertion. Is it or not?
Yes, sir.
But one of the party can go to the court for the restriction of the conjugal rights.
Mm.
If they did not go over there, means this fellow also wants to take the divorce. Is it or not?
Yes, sir.
Yeah, that is another point. So this way, but now there is no question of judicial separation now. Either you want to take the divorce or mutual consent. Over. There is no dragging procedure would be there. After life is short, dragging should not be there. Either you take the decision, yes, let us live comfortably, well and good. If not, better you have your own way of life. So there is only the 2 remedies are
Now,
available.
nobody is filing for judicial separation, sir. Only divorce and or restitution of conjugal rights, sir.
Yes. Now, but when you study, you have to study judicial separation also there. But in practice, when you come to the matter of the practice, even the judicial separation is removed also. They say the divorce only. Okay, separated wife. Then, in case of the judicial separation under this Divorce Act, the wife will, whilst so separated, be considered as an unmarried woman for a contract on the wrongs of injuries and suing and being sued in any civil proceedings, and her husband will not be liable to respect of any contract or the cost incurred or by during the separation. When the judicial separation would be there, for the husband, for the wife activity, husband will not be held liable vicariously. Vicarious liability will not play over there when there is a question of separated with the separated wife. So in every case of the judicial separation under this Indian Divorce Act, the wife will be considered as unmarried from the date of the decree while the separation continues. So that is there. That means no vicarious liability will take place when she is taken the judicial separation. So number 2, the separate wife will be The separated wife will be considered as the unmarried concerning the property of every description which she acquires. So when you say unmarried means he is not going to get anything in the form of inheritance. The property held by the separated wife can be disposed of by her in all respect as an unmarried woman. Suppose he's brought his own property from the father, whichever of the share which she is entitled to get it. In that property, without the interruption of anybody, she wants, she can dispose it. Are you following me?
Yes, sir.
Then alimony. Then alimony means here when two people are married, they must support each other. According to the Code of the Criminal Procedure 1973, the right of maintenance extended to any person economically dependent on the marriage. This will include spouse, dependents, children, and even indigent parents. There also comes under the picture. Okay, now the computing amount of the alimony, how it can be calculated. The alimony claim of either spouse, in vast majority of the cases, it is the wife, depends on whether the husband has a sufficient means. See, the question is, of course, now the women also earning members, and the earning members, women whose salary is more than the salary of the husband. So now, while deciding that alimony is to be paid, the court will take into account the earning potential of the husband. What is the status? What is the earning? Whether he is a professional or semi-professional or skilled man or unskilled man or casual labor. So these are all things will be considered before alimony is sanctioned to the divorced wife. Yeah. This ability to regenerate his future, whether he can come up with such a low class to the high class or not, the property is given to the wife to his liabilities. So if the property would be given or some of the amount will be given, whether he could survive or not, also taken into consideration. In some cases, the court can make an order to the husband for payment of the wife monthly or weekly sums for the maintenance and support. So either maybe the monthly or weekly or 15 days. In that way, they can be decided with about the understanding of the parties. The factors that influence the amount of the alimony. What are the factors? As I told you, the alimony amount depends upon the length of the marriage in a contested divorce. Divorce after a decade of the marriage and entities entitles the spouse to live lifelong alimony. So the other important factors that need to be considered are given here. Yes, can you read this? Yes. At least read 2 bullets.
Age of the person who is entitled to receive the alimony, the economic condition to the condition or the earnings potential of the person who is entitled to pay alimony.
Yes,
the health
enough. I say enough. Only 2 highlighted. So age of the person who is entitled to receive the alimony. What is the age of the person who is entitled to receive the alimony? Whether the old one, whether the young man. If the young woman would be there is a possibility that she is going to remarry. So next condition is the economic conditions or the earning potential of the person who is entitled to pay the alimony. So a person who is going to pay the alimony, his earning potential also taken into consideration, plus economic conditions and dependence on him. The health of the spouse and the failing health and medical condition of one of the spouses who is going to receive the alimony may act in favor of him or her. They can claim larger alimony by their failing health. Suppose if the woman is suffering from many other diseases, chronic diseases would be there, then the alimony amount will be the bigger one. Okay, the spouse who retains the custody of the child would be entitled to either by lesser alimony or by the entitled to greater amount which the child is minor. Of course, some of the spouse, what they do regarding the child custody is concerned, they will spend a lot of money to see that the child would be with them. And some people, they let the child, wherever he may be, let him be happy instead of falling the divorce impact upon the child. So now property settlement, how it will come into the picture. So according to the Indian Divorce Act, if a person is married, irrespective of the fact that the divorce petition has been filed, the person has the right to occupy the property, definitely. In case the person is looking after children, the case is much stronger, while the property may be granted to one or the other spouse in the divorce settlement. Both the wife and husband have the right to remain on the property until the decree from the court. Yes, up to that extent, they can stay over there. Then the child custody is concerned, I already told you the best interest of the child. That is the UNCRC provisions are followed over here. That is ratified, signatory, ratified, and promulgated in the local in the sense municipal laws. Yes, the courts will usually agree to the decision of the parents in a mutual consent divorce. So the courts will be expected to check the best interest of the child. I told you already, the best interest of the child. That principle should be followed. In case of a contested divorce, suppose the wife is contesting why the child, because child below the age of the 7, if the child is she, if the child is he, the 2 years. In sometimes even that the dichotomy, that distinction can be overlooked also, because the following the best interest of the child. So, as stated above, non-working mothers are regularly given the custody of their children, but fathers are expected to provide the financial support. So, generally, these are the things which is going on because of the India is our patriarchal society, and whose domination is more?
Male domination.
It is the patriarchal means paternal side, male domination is more. So no more about the custody of the children in India. So that is those things where we can make it out. Of course, the following documents have to fulfill the divorce. What are the divorce documents should be there? It is mentioned over there. What is the procedure for filing the divorce? Also put it over there. The petition must be shared the following details. So when you want to file a case in the court of law, then what details should be there? Let us see one after another. Name of the parties, it is a must. Status and domicile of the parties, yes, because they want to claim the amount and the form of alimony. So date and place of marriage, yes, must, because the court is having the jurisdiction to enter in such a case or not, also be taken into consideration. And remember, next point is the principal permanent place where the parties cohabit. Yes, because where the BBC for the longer time would be there, so that also be taken into consideration. And a place where the parties last resided together. When they departed together, where they last resided together, that also an important factor. Name of the children of the marriage, if any, with the date of the birth. Suppose the consummation was there, the BBC was there, then she got the pregnant and having the 1 or 2 children, then the date of birth of the children is more important factor. The ground of the seeking divorce or separation. So what are the ground we should have to show to get the dissolution of marriage? And that is the must point. Next point is the facts and details by which the petitioner seeks their relief. What are the relief the petitioner wants? Because he says, let our half of the life is over, only second half is left over there. Better let we have a mutual consent. You live your life according to your own style. I live my life according to own style. They will make it out. So the details of the petitioner seek the relief. What relief that you want, also they can make it out. The relief is better will take the mutual divorce. So that the parties are not deceiving the court by the collaborating. So the party should not be in a deceiving stature to make the belief to the court that they are collaborating. Such a collaboration should not be there. So the government made or verified either 6 months a couple has to reappear in the form of in the front of the court after filing the second motion for the mutual consent divorce. Of course, when the motion for the mutual consent, they have given the 6 months time will be given over there. After hearing from both the husband and wife, if the judge is satisfied that the all essential grounds for the filling the recruitment and meeting of the methods of the divorce or couple grants a mutual divorce decree. All the conditions are fulfilled over there as it is enumerated earlier, then the mutual consent will be given, a decree can be given on the spot. Then the custody of the child, alimony to wife, and litigation expenses will be considered in the issue of the decree of the divorce. So custody of the child is an important factor, and who has to maintain the child, and the widow, or not a widow, that is a divorced wife, and regarding the alimony is concerned, and how much should you have to pay it, and what should be paid over there, all these things will be taken into consideration by the court. So these are the certain things which I want to share to you regarding the
Silent features, matrimonial remedies under the Divorce Act, sir.
yeah, not the alien features it is. It is the matrimonial remedies. If you take the Hindu Marriage Act, also same matrimonial remedies. You take the Christian Marriage Act, also almost all the same matrimonial remedies. And if you see the Divorce Act, then the almost all the same matrimonial remedies are available. Because somewhere the remedies are more, somewhere the remedies are less. Only less and more is there, but Remedy is remedy. Even the less or more, it doesn't make any difference. So with this, I would like to
Sir,
wind up.
if
Yes.
divorce is granted, then the judge will also grant maintenance, or it should be uh, filed another way, another petition for maintenance.
Yeah, because when the case is pending over there in the court, yes, the pendulite is there, he has to pay the maintenance till the judgment is over. Again the point comes over there. Suppose she did not go to suppose it is in your favor, and
Mm.
and the other party will not go for the appeal. The appeal period is over. At that instance, there is no question of paying it because it is in your favor. In case,
ఇప్పుడు డైవర్స్ సార్, ఇప్పుడు డైవర్స్ అప్లై చేసినప్పుడు మెయింటెనెన్స్ కూడా దాంట్లో రాయొద్దంట కదా సార్? మెయింటెనెన్స్ వేరే సపరేట్ గా అప్లై
see,
చేయాలంట.
when you go for the divorce, naturally all the points will come. If it is not there, the judge will ask you, okay, now you are going to take the divorce. Okay, these are the grounds you filed a case. Okay, what about the children? What about the property? What about the maintenance? What about the taking care of the father and mother? So all the things will be taken into consideration. So that is the say matrimonial remedies. If once the divorce is given, what would be the impact on different places? So these are the things will be decided by the court, and court will keep it in the mind. Okay, till the case is decided, this much alimony would be paid to her. So every month you should have to pay it. If that fellow is a casual labor, now you tell me. If he goes to the duty, then only he will get the money. There is no permanent money for him. If the duty is there, he will get the money. If the duty is not there, then he will just come and eat somewhere whatever the left over there in the yesterday's food. Then how could you expect that he will pay it? Because both of them will work and they only survive. If one will take the divorce, then there is no question of even filing a case also. Because they don't have that much money to even file. If you want to go, okay, go away. There's only the remedy. Are you following me?
Sir, many labor families, they will only live separate for years and years. They will not even go for a divorce.
See, the poor people, they don't ask any divorce, and either they stay together or they will seek their own partners.
Again, they
Only the
will
rich
marry
people.
another one, sir. They will marry another when one also.
If
Nobody asked.
see, suppose nobody would ask you, the husband married together, wife, okay. After sometimes the husband living with another woman and the wife is living with another man. Who will question you whether you have taken the divorce or not?
Yes, sir.
Now, who will question? You tell me.
Nobody will
Suppose,
question.
suppose if anybody question you, yes, we are mutually felt we are not compatible to each other. So she took the another man and I took the another woman. Because regarding the property is concerned, if they work, food is there. If they don't work, no food is there. Where is the question of inheritance? Tell me. It is only the middle class people this comes over there. And of course, the very high class people, they don't care at all. Okay, you want to live, you can live separately. Okay, bye. The mutual consent, or they want to contest, let the contest. It will take its own time, years together. So better, the last resort is not to take the divorce. That is the only thing. Always, settlement is the best judgment. Even myself also say the same thing. Because after a man is having a life, how much life? How much year you live? 60 years, 70 years. Okay, at the most, 80 years you live it. In 80 years, all these repercussions would be there. Then 40 years will go in this one only. Rest of the 20 life you